The algorithm wasn't just code. It was 17 years of my life compressed into 400,000 lines, and the Department of Defense had placed a classified restriction on 3 of its core modules because nothing else in the private sector came close to what it could do. I want you to understand that before anything else. Before I tell you what my brother-in-law did. Before I tell you what happened on the morning of March 4th. Before I tell you about the conference room on the 32nd floor and the 6 people who wouldn't look me in the eye. You need to understand what was actually at stake. The system I built was a predictive logistics engine for autonomous supply chains. Defense applications, yes, but also civilian infrastructure, ports, rail networks, cold chain pharmaceutical distribution. The kind of backbone software that doesn't make headlines but keeps everything moving. I'd started building the core architecture in my garage in Reston, Virginia in 2007, when my daughter was still in diapers and my wife and I were sharing one car. I filed the first patent on a Tuesday. I remember because it was garbage day and I forgot to take the bins out and my wife didn't speak to me until Thursday. The company that eventually licensed the technology, let's call it what it was, the company my father-in-law founded and that I had helped build from 12 employees to over 400, had been using my architecture as the spine of their flagship product for 11 years by the time any of this happened. 11 years. The licensing agreement was airtight, negotiated by my own attorney, and buried inside Section 9F was a clause that most people glossed over because it was dense and technical and sounded like boilerplate. It was not boilerplate. I'll come back to that. My brother-in-law, my wife's younger brother, the one who had failed out of his MBA program at George Washington, and then somehow talked his father into making him chief operating officer, had been maneuvering for about 18 months before the morning everything came to a head. I could see it happening in slow motion, the way you sometimes can when you're close enough to a situation to feel the pressure building, but too deep inside it to know exactly when it's going to crack. He'd started reassigning members of my engineering team without telling me. Little things at first. A senior developer moved to a different reporting structure. A product manager who'd been with me since year 2 suddenly answering to a different VP. I raised it with my father-in-law twice. He waved it off both times, said it was growing pains. Said the company needed to mature its organizational structure. Said, and I remember this specifically because it landed like something rehearsed, that he hoped I wasn't letting ego get in the way of what was best for the business. I was 44 years old. I had built the thing that made that business worth anything. I let it go. I shouldn't have. In January of that year, my brother-in-law had quietly commissioned an internal legal review of the licensing agreement. He didn't tell me. He didn't tell the general counsel either. He brought in an outside firm, a boutique IP shop in McLean that had done some other work for the family. The review came back, as I later found out, with a memo that said the agreement had potential vulnerabilities if the company could demonstrate that the architecture had been substantially modified over the years of use. It hadn't been, but that memo was all he needed. On March 4th, I got a calendar invite at 7:40 in the morning for a 9 o'clock meeting. No agenda. No attendees listed beyond the names. My brother-in-law, the outside counsel from McLean, HR, and my father-in-law, who I noticed had been copied but not listed as a required attendee. I knew. Not the specifics, but I knew. I stopped at the coffee machine on the 2nd floor, the decent one, not the one by the stairwell that burned everything. And I stood there for a minute with a cup I wasn't going to drink, and I thought about calling my attorney. I decided not to. I decided to walk into that room and let them show me what they had first. The 6 engineers on my team who were already in the building kept their eyes on their monitors when I passed through the floor. That told me they'd been told something. Maybe not everything, but something. The conference room on the 32nd floor had a view of the Potomac on a clear day. It was overcast. My brother-in-law was standing at the head of the table when I walked in, which was a staging choice. He'd thought about this, had positioned himself at the head before I arrived so that I'd have to sit to the side. Small power move. The kind of thing you learn in an MBA program you don't finish. He didn't wait for pleasantries. We've completed a review of the IP licensing structure, he said, and based on the evolution of the product over the past decade, legal has determined that the original agreement no longer reflects the reality of ownership. We're restructuring. The company will be filing for independent patent recognition on the modified architecture effective today. Your consulting agreement is being terminated as of this morning. I looked at the outside counsel. She was studying the table. I looked at HR. Same. I looked at my father-in-law, who was sitting at the far end of the room and who did not look at me at all. I set my coffee down. Did legal walk you through Section 9F of the original agreement? I asked. I kept my voice completely level. The full version, not the summary. My brother-in-law smiled. Not a good smile. The smile of a man who has already mentally spent the money. We've reviewed the agreement in its entirety. That's what I'm telling you. Okay, I said. And the biometric filing confirmation? The federal registration timestamp? The smile stayed. We're aware of the patent registration. The original registration, I said. Not the one you're filing today. The one that was registered under a dual lock authentication protocol. The one that requires my biometric confirmation for any ownership transfer to be recognized as valid by the USPTO. The smile flickered, just for a second. That's a procedural matter that our attorneys are. It's not a procedural matter, I said. It's a hard block. The patent cannot be transferred, assigned, licensed, or claimed by any other entity without my active biometric authorization. That authorization was never given, which means the filing your attorney submitted this morning, and I'm assuming they submitted it this morning, given the timeline, triggered an automatic flag to the USPTO Office of Patent Enforcement. The outside counsel looked up. It also, I continued, because I had been waiting to say this for about 3 weeks, triggered a notification to the Defense Contract Audit Agency, given the classified modules, and to the SEC because the companies publicly traded and an unauthorized IP transfer of this magnitude constitutes a material misrepresentation to shareholders. The room was very quiet. I'd like to have my personal items from my office, I said. I'll see myself out. I didn't take the elevator. I took the stairs. All 32 floors. Not because I was making a point. Because I needed to move. Because my hands were shaking and I needed to do something physical before I got to my car and called my attorney and finally said the words out loud. What I hadn't told them, what they wouldn't understand until the following morning, was that Section 9F also contained a provision I had insisted on during the original negotiation, and that my father-in-law had signed without fully reading. In the event of any unauthorized claim or transfer attempt on the core architecture, a licensing revocation protocol would automatically engage, not immediately, on a 72-hour countdown to allow for legal remedy. The countdown had started the moment they filed. My attorney called me at 10:15. I was sitting in my car in the parking garage with the engine off. They filed at 9:07, he said, sloppy. They didn't read the secondary provisions. I know, I said. The revocation protocol is active. They have 72 hours to withdraw and restore the original agreement, or the license terminates automatically and the underlying architecture becomes inaccessible to them. I know, I said again. Do you want me to reach out and tell them? I thought about my brother-in-law's smile. I thought about the 6 engineers who wouldn't look at me. I thought about the cup of coffee I never drank. I thought about my father-in-law at the end of the table, looking at nothing. No, I said, let it run. What I didn't expect, what I hadn't fully gamed out, was how fast it would hit the public side. By 11 the next morning, the company's flagship logistics platform had begun throwing errors, not catastrophic failures. Degradation. The kind of cascading minor failures that look like infrastructure issues until someone smart realizes they all trace back to the same core module. By 2 in the afternoon, 3 major port clients had flagged the errors to their own engineering teams. By 4, one of those clients, a publicly traded shipping company, had issued a statement saying they were investigating operational anomalies with their logistics software. The stock dropped 4% before close. My brother-in-law called me at 4:47. I didn't answer. He called again at 5:20. I sent it to voicemail. At 6:03, I got a call from a number I didn't recognize. I almost didn't pick up. It was a woman's voice, young, speaking quietly, like she was in a stairwell. I don't know if I should be calling you, she said. I'm in compliance. I've been here 2 years. I thought you should know that they're in damage control mode, and nobody here actually understood what Section 9F meant until about an hour ago. How many people know? I asked. The whole floor, she said. And honestly, most of them think you're right. I thanked her. I never found out her name. The next 36 hours were something I can only describe as watching a building you helped construct slowly lose power, floor by floor. By the morning of day 2, the degradation had spread to the secondary modules. The shipping company's statement had been picked up by the trade press. A reporter from the Wall Street Journal had called the company's communications team asking about the IP dispute. Somehow they'd gotten wind of the USPTO flag. The stock dropped another 6%. My brother-in-law's attorney called my attorney at 8 in the morning and asked if there was a path to resolution. My attorney called me. They want to know if you'll authorize a pause on the revocation protocol. Tell them the protocol doesn't pause, I said. It resolves or it terminates. Those are the two options. At 1 in the afternoon on day 2, my father-in-law called me directly. First time since the meeting. I sat with the phone in my hand for 4 rings and then I answered. Son, he said. He always called me that, even now. I'm here, I said. A long silence. Outside my window, the neighbor's dog was barking at something in the yard. I didn't know the full scope of what he was doing, he said. I want you to know that. I didn't say anything. He told me it was a restructuring, a formality. He said you'd been informed. I hadn't been informed, I said. I know that now. Another silence. The board is meeting at 3, he said. I want you to know I'll be telling them what I know. Okay, I said. Is there anything? He stopped. Started again. Is there a way to stop this? There was, I said. For about 71 hours, that window is almost closed. He didn't say anything. I'm sorry, I said, because I was. Not for what was happening, for what it meant. For the thing that had broken between us that probably couldn't be fixed with a phone call or a board meeting or anything else. He hung up. I sat there for a while. The 72-hour mark hit at 9:07 in the morning of March 7th, exactly 3 days after my brother-in-law had stood at the head of that conference room table with his smile that already knew how to spend the money. The license terminated. The core architecture became inaccessible. Not deleted. I want to be precise about this. Encrypted. Behind a key that only I held. The company's flagship platform, the product that accounted for 63% of their annual revenue, went dark. Not slowly, all at once. I was at my kitchen table when my attorney confirmed the termination. I had a cup of coffee, a decent one, from a machine my wife had picked out years ago that I'd never paid enough attention to. I sat there in the quiet, and I thought about the garage in Reston, and the garbage bins, and the Tuesday when I filed the first patent, and what it had felt like to believe that building something real was enough protection. It isn't, I know that now. The document is the protection. The clause is the protection. The 72-hour countdown that nobody reads until it's already counting. The board removed my brother-in-law as COO 3 days later. He did not go quietly, but he went. The SEC investigation took longer. 8 months, in the end, before they issued findings. The unauthorized IP transfer attempt, combined with the material misrepresentation to shareholders, the company had issued an investor communication 2 weeks before March 4th that implied clean ownership of the core architecture, resulted in charges, civil charges, and then, after the DOJ reviewed the referral from the SEC, criminal charges for securities fraud. My brother-in-law spent 14 months in federal prison. I'm not going to pretend I felt nothing about that. He's family, technically, his mother cried. My wife didn't know how to feel and I didn't either for a while, but he had stood in that room and smiled and said, "We've reviewed the agreement in its entirety," knowing that he hadn't, knowing that what he was doing was fraud. And when you make that choice, you've made it. The consequences belong to you. My father-in-law stepped back from day-to-day operations 6 months after the termination. He and I have spoken a few times. Not often. There's a version of our relationship that survived this, and a version that didn't. And I'm still not sure which one is real. He came to my daughter's graduation in May. We shook hands. That felt like something, even if I couldn't say exactly what. The company eventually entered into a new licensing negotiation with me. A real one this time, with every clause read and initialed and explained. The terms were substantially different from the original agreement, more favorable to me by a significant margin. My attorney made sure of that. So did I. I didn't take that deal. In the end, I didn't. I had spent 4 months by that point working out of a rented office in Arlington with 3 engineers who had quit the company the week after March 4th and found me. We were building something. Not a rehash of the old architecture, something new. The classified modules were still restricted, which meant certain defense applications were off the table for the time being. But civilian infrastructure had no such limits, and the market for what we were building was larger than anything I'd had access to inside the old structure. The first contract we signed was with a regional rail authority in the Midwest. Not a glamorous deal. Not the kind of thing that makes headlines, the kind of thing that keeps trains running on time in places where people need them to. We signed it on a Wednesday afternoon. Afterward, the four of us walked to a diner 2 blocks from the office and ordered coffee and pie. The coffee was mediocre. The pie was excellent. One of the engineers, a woman who'd been the most senior person to follow me out, 11 years with the old company, looked around the table and said, "So, what are we doing next?" I pulled out the folder I'd been carrying for 3 weeks. There were 6 more proposals in it. Port authorities, pharmaceutical distributors, a municipal emergency services network in the Southwest, things I'd been working on quietly, in the margins, in the same way I'd once built the original architecture in a garage while the rest of my life was happening around it. "Pick one," I said. "The office is small. The team is still young. The coffee machine is terrible. A drip unit from 2019 that takes 12 minutes to produce something barely drinkable. And I keep saying I'll replace it, and I haven't. But every patent on the wall, and there are 4 of them now, has the right name on it. Mine." I think about the garbage bins a lot, actually. That Tuesday in 2007, when I forgot to take them out because I was too focused on a patent filing. It sounds ridiculous, but that's where this whole thing started. In a garage in Reston, with a bad chair and a cheap monitor, and the absolute certainty that if I built something real, something that actually worked, that would be enough. It wasn't enough. I know that now. And I think that's the first thing we're saying out loud. Building something isn't protection. Talent isn't protection. 17 years of showing up and doing the work isn't protection. The document is protection. The clause is protection. The part nobody reads until the countdown is already running. That's what protects you. I spent the better part of 2 decades believing that the quality of what I created would speak for itself. And in the end, what spoke for me was 4 paragraphs buried in Section 9F that I had insisted on and that my father-in-law had signed without fully understanding. I don't say that to sound clever. I say it because I almost didn't insist. My attorney pushed for it, and I remember thinking it was excessive. I remember thinking nobody would actually try to do what my brother-in-law eventually did. You want to believe that the people around you, especially the ones connected to you by family, operate with some basic level of integrity. Sometimes they don't. And when they don't, what saves you isn't how hard you worked or how much you contributed. It's whether you were clear-eyed enough to protect yourself before you needed to. That's something I had to learn the hard way, and I think it's something most people who build things, really build them, with their hands and their minds and years of their lives, eventually have to reckon with. The world doesn't automatically reward you for what you create. It rewards you for understanding the rules of the game well enough to survive when someone decides to play dirty. But here's what I also learned, and this one took longer to settle. Surviving isn't enough if you let what happened turn you into someone who doesn't trust anything or anyone anymore. I watched my brother-in-law make choices from a place of pure entitlement and zero accountability, and I watched where it led him. I didn't want to become the opposite version of that. Someone so armored by what he'd been through that he couldn't build anything with other people again. The 3 engineers who followed me out the door, the woman who had been with the old company for 11 years before she walked away. They took a real risk doing that. They believed in the work more than they believed in the institution. That kind of trust deserves to be honored. So I kept going. Not because I wasn't angry, I was for a long time, but because the work was still real. The thing I had built still mattered, and there were people willing to bet their careers on what we could do next in a rented office in Arlington with a terrible drip machine and a stack of proposals I'd been quietly assembling for 3 weeks. My father-in-law called me son on that phone call, even after everything. I haven't forgotten that. I'm not sure what to do with it yet. Some things take longer than a year to understand. The office is small. The coffee is still bad. But every patent on the wall has the right name on it. That's not nothing. After everything, that's actually quite a lot.